Welcome to Division 5 of the Colorado Court of Appeals. My name is David Richmond. To my right is Judge Gil Romat. To my left is Judge Michael Berger. We have two cases on the 9 o'clock docket today. Ray versus, if I'm pronouncing this right, Levisone, and Avenue Capital Management versus Shaden. Are all the lawyers present who are in those two cases? Okay. And then we're going to probably take a recess after the first two cases, and the 10 o'clock docket we will continue with later. Just a couple of announcements. Everybody who's in the audience who has any kind of electronic device, please turn them off so they don't beep or interfere with the communications. Each side has 15 minutes in both arguments. If the appellant wishes to reserve time, of course they may, but there's a clock on there. It's up to you. We're not going to throw up a flag or anything to tell you you have X amount of time left. Please stay close to the podium because these proceedings are recorded for posterity. And unless anybody has any questions, we're ready to proceed. You may come forward in Ray versus Levisone. Counselor Appellant, you may proceed.
Good morning, Your Honors. I hope today turns out to be better than yesterday with our Rockies and Denver teams.
And I'm a Cubs fan, so it was a double bad day. Not to mention the Broncos.
Your day is today then, right, I think. You know, this case, I'm sure
Your appearance, counsel.
Mark Herber.
Thank you, Mark.
32036. May I proceed?
Yes, please.
All right. This case has been a long and difficult case. It's been extraordinarily difficult to place this ditch in a ditch easement to sort of summarize what this case is about. The Rays are seeking a new ditch to place in an existing ditch easement that obviously is between the Levisone and the Cage properties. The appeal briefs have been filed. I'll try not to simply read from them, but I think the first issue is whether or not the trial court appropriately placed the burden of proof of an affirmative defense of practicality and feasibility on the Rays.
Does it matter on this record? I mean, the trial court had or heard evidence from both sides, made findings of fact. What difference does it make where, even if the trial court erroneously imposed the burden on one party, on this record, what difference does it make?
I think that the trial court order was very clear. In multiple instances, the trial court said the plaintiff failed to prove, the plaintiff failed to prove, the plaintiff failed to prove. And that's not the case. It wasn't the plaintiff's burden of proof. I mean, that's basically it. You know, the burden of proof is important, and I think the case law that we cited is clearly important. And I know this court has reversed cases because the burden of proof was incorrectly or placed on a party when the law requires the defendants in this circumstance to prove certain things.
In similar circumstances where the trial court heard conflicting evidence, made findings of fact by the preponderance of the evidence standard, you're saying this court or the Colorado Supreme Court reversed such a judgment based upon the improper allocation of the burden of proof?
I think that the burden of proof is important, and I think I have seen appellate cases where if the burden of proof was inappropriately placed on a party, and I think we cited some of those cases here in our brief, that the court did not make any findings of what the defendant did or didn't prove in this case. The court made findings that plaintiff didn't prove issues concerning this ditch, and the decisions from the courts have been pretty clear as to who has the correct burden of proof, and that is an affirmative defense to be proven by the defendants concerning feasibility and practicality. The Warner v. Town of Gunnison case, the San Luis Land Canal and IMP Company, Kenilworth Canal, and the Atlantic and Pacific Company versus Barnes case all indicate that the practicality and feasibility on this particular statute is an affirmative defense to be demonstrated by the defendants and not by the plaintiffs. And the court held the plaintiffs in this case responsible to make that proof and then decided that the plaintiff didn't make that proof. But what's important is that the defendant had to make proof that this ditch was feasible and practical, as opposed to the plaintiff proving that it was not feasible and practical.
If we were to agree with you and sent it back for presumably a new trial where the burden of proof, as you see it, was correctly allocated, do you really think there is going to be a different result?
What I think is there has been a trial already, and the court has the record in front of it, and the court can determine that there was no evidence that was presented at all associated with any repairs to this ditch or modifications to the existing ditch that could have delivered sufficient water from the point of diversion to the point of use. All of the evidence at trial dealt with systems, improvements that could have been made to the Ray's property after the point of the delivery. The Court of Appeals on remand asked the trial court to make some determinations, and it didn't suggest who had the burden of what proof, but asked that what the court needed to determine is what could be done to the existing ditch to make it, or if it could be feasible and practical to irrigate all of the Ray's property. What I'm telling you is it is undisputed. There was no evidence at trial that anything could be done to this ditch to make it deliver sufficient water and all of the Ray's water rights to sufficiently irrigate all of their property. Everything that was discussed at trial was all about what could be done on the Ray's property after the point of delivery, because it's uncontroverted that this ditch delivers water in an inconsistent, inappropriate manner to irrigate all of the Ray's property. So I don't know. I think if the trial court sent it back down, there was no evidence at trial as to what could be done to this ditch. That was what the Court of Appeals said, and that is the correct position to be taken by the trial court, and that's not what was taken.
Counselor, can we switch gears? I want to ask you about the procedural issue that's out there. I know it's your position that, or at least as I understand it, that you don't have an obligation to make a good faith offer in this case. I take it that is your position. Would you agree that that's your position before I ask you the follow-up?
I would agree that our position is that the case law suggests that what needs to happen is there needs to be a failure to agree on compensation, and the parties need to negotiate in good faith. And I would suggest that there is no evidence in the trial court's order that did not take place. There is no dispute that there was a failure to agree on compensation. There is no dispute that the parties negotiated in good faith. There is no dispute that the defendants refused to allow the plaintiffs under any circumstances to pull an earthen ditch, and that's what they would have been that's what they were seeking through condemnation, was an earthen ditch.
So is it your position that a good faith negotiation did occur then, or that it wasn't required?
A good faith negotiation did occur. What happened is the plaintiffs approached the defendants and said, we would like a ditch here over multiple periods of time at multiple events. And the defendants said, we're never going to allow you to have an earthen ditch. However, if you would agree to pipe portions of that ditch in this same area, we'll allow you to do that. So then the discussions for a year and a half leading up to before the filing of the suit were about what's it going to take to get a portion of a ditch through a pipe system in this area where they're wanting to have, the plaintiffs are wanting to pull a ditch but turn it into a pipe. So the discussions went there. There was a consolidated exhibit, a 1006 exhibit, that detailed years of email communications trying to work to make that happen. What I'm saying is technically, the Rays said, what can we do to get an earthen ditch? The defendant said, you're never going to get it, but we might let you install a pipe system if you can design it this way and show us this design and do this. So then the parties went that way. And then once, after years went by and attempts to negotiate that failed, that's when the condemnation suit was filed as an alternative to the other claims for quiet title.
Is it true that the only monetary offer that was made by your clients to the Lavazone and the other landowner was $10?
What happened at trial, Your Honors, the court identified that issue.
Well, I'm asking you, is that an accurate statement?
As far as a monetary offer, a written cash offer,
Right.
yes, but that was not even intended to be a cash offer. That was in the easement agreement that was part of the negotiations for purposes of building and constructing a piped ditch. So that was part of the negotiations for building a pipe ditch, not an earthen ditch. The earthen ditch was refused off the bat.
So there never was then, if I'm hearing you right, there never was a cash offer made by your clients whereby they said, we will pay you X dollars to use your land to build this new ditch.
You're talking about prior to the condemnation proceedings? Because during the condemnation proceedings.
to.
Okay. During the condemnation proceedings, it happened frequently. I have letters, they're
Okay.
exhibits. But
prior
prior
to
to, the conversation was you're never going to have an earthen ditch. So that's correct.
Could you just please answer my question? Is it true that prior to the filing of the condemnation proceeding, there was never a cash offer to use the Lavazone's land?
There was an offer for an engineering solution that was about $30,000, which is what they
I don't
asked
know what
for.
that means. What does an engineering solution mean?
What the defendant said is you can't pull an earthen ditch, but you can pipe it and go under the cul-de-sac with a piping system. So you have to have an engineered solution to make that happen across the Lovison and the Cage property. And the Rays were willing to spend the $30,000 on the engineered solution that the defendants wanted, and they presented that to them. Then the negotiations broke down after that point.
But that wasn't a payment to the Lavazones, that was a payment for the construction of the ditch, is that right?
That was a payment for the construction of a piped solution that the defendants requested in lieu of an earthen ditch. So the Rays were willing to pay for an earthen ditch. The defendant said, you're never going to get it, but we'll let you pipe portion of the ditch in this area, but you have to go have your engineers draw it up, make a plan. You have to have crossing agreements. There's all kinds of issues you have to do for that plan. And the Rays did that, and they spent the money doing that. And then that agreement fell through. And since if they're not going to let, if they weren't going to let, the defendants weren't going to let the plaintiffs have that solution, then, or an earthen ditch, there was nothing left for them to do except to file suit. And I would like to reserve the rest of my time for rebuttal.
Okay, can I have 4 minutes and 21 seconds approximately? Counsel for appellees.
Thank you, Your Honors. My name is Jim Cage, 10153, representing Sylvia Lovison and Don and Peg Cage in this matter. The court sent out an order prior to this hearing saying that it would like some discussion potentially concerning the phrase authorized by law contained in 38 CRS 38-1-122, which is the attorney's fees section.
Before you address that.
Yes, sir.
Let's talk about the merits a bit. Could you answer the question that Judge Berger just asked Mr. Herber? Was there ever a monetary offer to your clients for use of their land across which to construct any kind of a ditch?
In fact, there was not, Your Honor. In fact, if you look at the transcript of Jim Ray, transcript page 136 and 137, Mr. Herber stipulated on the record that there was no offer of compensation except this $10 recitation of compensation of compensation, and all it was a recitation of we're gonna for good
$10 and
$10 and other reasonable
Right.
consideration, we're gonna do this. But it wasn't only a recital, it was not contained in the actual offer. They
Tell
didn't
us,
say, we're gonna pay you $10.
tell us again where you just found this in the record. I'm sorry, sir. You said it was
Jim
in
Ray's testimony,
during Jim Ray's testimony, they made a stipulation. Herbert made a
transcript page 136 and 137.
Thank you.
He stipulated that other than that $10 recitation,
Okay.
which is all it was, there was no offer of compensation in the case.
Thank you.
Dealing with the feasibility issue as well, the feasibility and practicability issue was brought to the party's attention in connection with the previous appeal in this case. And in connection with that, the court assumed, we believe the Court of Appeals assumed that there was a necessity requirement which would be defined as reasonable and practicable under the statute dealing with 2 ditches on 1 property. We think that the burden of proof issue is kind of a false issue. And we think that's a false issue because the evidence was so overwhelmingly, there was just really no dispute that the current ditch was practical and feasible. And I could give you a couple of quick examples. The current ditch was-
Before you go there, so you're saying that it doesn't matter if the trial court erroneously allocated the burden of proof because the evidence was so one-sided?
We think that's correct, Your Honor. We think first off, we think the plaintiffs had the burden of proof for a whole bunch of reasons that we cited in our brief. Second off, it really doesn't matter. And the reason it really doesn't matter is because the evidence was overwhelming that the ditch was practical and feasible for every purpose whatsoever.
But don't the cases that Mr. Herbert cites pretty clearly stand for the proposition that it is an affirmative defense?
Those cases were cases that dealt, yes, those cases were cases that dealt with that statute in particular, the statute dealing with 2 ditches on 1 property. What happened in the previous action, in the previous appeal on this, we had won on summary judgment because they hadn't met their burden to prove necessity. This court assumed that there was, for the limited, they said there was a dispute as to whether or not necessity was required in this kind of accommodation, but we're going to assume that it is required, and we're going to define that as reasonable and practicable, as set forth in that statute dealing with 2 ditches on 1 piece of property. And so we think it's really an element of necessity, which the burden of proof is on them. We also think that they assumed the burden of proof because they put on evidence from Mr. Ray, Mr. Brothers, Mrs. Ray, and other evidence in their case, in their opening argument, and in their case, showing that they believed it wasn't practical and feasible. But the overwhelming evidence was that it was clearly practical and feasible. This is a ditch that's been in operation for almost 25 years. It has delivered every drop of water to the Rays property, either to their predecessor in interest or to the Rays for the past 25 years. They initially only had 1 share of water, now they have 6. Every drop was delivered to them to their point of interest. That should be enough to win the case right there, because
But why? I mean, if part of their land, as I understand it, part of the Rays' land is at a higher elevation than where the water comes out, gravity would not permit that water to go upward. So why do you say it's just so obvious that that ditch is sufficient?
Well, that's just the first part of the argument, but I say that that is sufficient and that should be sufficient enough. And the reason is we cannot find 1 scrap of evidence, 1 piece of authority, or anything else that a party has a right to bring a ditch anywhere they want it to bring it across to their own property or any elevation. Every other property owner in this subdivision cannot irrigate by gravity irrigation their whole thing. Once they get all their water, we don't care what they do with it. They can put it in a pond and pump it around. They can put it in a pond, grow catfish. They can gravity irrigate it. They can take buckets and water each blade of grass by hand. It doesn't matter. The law is that we can find is that we have to deliver the water to their property and whether that's practical and feasible.
So if a pump system that would adequately irrigate the upland portions of the Rays property, say, would cost hypothetically $1 million, your legal position is it doesn't make any difference because the water is delivered to some portion of the Rays property?
I think theoretically that's correct, Your Honor, although $1 million is kind of out in the Netherlands. What we had in this case is their expert testified it would cost them $19,000. Well, first off, they've got a pump system in place for $500 or less, by which they can irrigate 100% of that top portion of their property, that acre and a half, that's the only part above where the property enters. But they irrigate more than that with it. They irrigate about 5 acres, all of the property above their driveway. Mr. Ray testified he could do it, and in fact did it. He did it from the years when he got enough water shares. That's when he first started irrigating that property, and that was in about 2006. He irrigated that upper section from 2006, 7, 8, 9, 10, 11, 12. He quit in 13 because that's the first irrigation year. That's the first irrigation year after this litigation was commenced, and he quit doing it, saying it was too inconvenient at that point to do it. But Mr. Ray testified he could do it. Mr. Brothers testified it was feasible and that he could get the property he could get it to the top of the property. Not only that, but Don Cage, was over there 10 or 20 times. He saw the pump, he saw it in operation, he saw the pipes, he saw the water being delivered to the top of their property. And as he drove by the place to get to his house, he saw it as well. In addition to that, Ms. Lovison testified that it could be done. It was able to get it to the top of the property, and he did. We introduced Exhibit 213, which is aerial photographs showing, in fact, they were irrigating that property for that period of time with their current $500 pump. Now, there was a ton of testimony concerning costs of maybe improving that system. And Mr. Brothers, their expert witness, came up with a figure of some $19,000 if you didn't bury the pipe up to the top, whereby you could irrigate the top for $19,000 by putting in a 7.5 horsepower electric pump and doing some other things and piping the solution up there, and you could do it. And Mr. Cage testified it would only cost you $13,000, but the district court relied on their expert, Mr. Brothers, saying you could do it. But the testimony was overwhelming that you could do it, and you could do it for as little as, not $1 million, but as little as $19,000 for an approved system, or the testimony was undisputed that they got the water to the top with their $500 pump that they bought in 2006, and they could still be using that pump to irrigate up there if it wasn't too inconvenient for them. The other part about this inconvenience thing is really quite telling. The only farmer that we actually had testify in this case was a guy named Denny Malachar. Denny Malachar has been a farmer since he was 5 years old. His whole life he's done it, he testified. He currently farms about 880 acres. He says, and he farms Ms. Levison's property, and he farms the Cage's property. He's familiar with the ditch at issue. And he says all irrigation ditches, not this one, they're subject to silt, they're subject to flooding, they're subject to all of those things that they're complaining about are inconvenient, to trash in the ditch and those sorts of things. The testimony was that Mr. Ray did practically nothing to improve the ditch, and you can find that testimony. Well, I don't have that site in front of me right there, but he testified that he practically did nothing to improve the ditch other than to burn a few weeds out of it and occasionally pull it a little bit. But Mr. Malachar said, there's nothing wrong with this ditch. You got silt in every ditch you got. You got possibility of flooding, you got weeds, you got trash in all of the ditches, no matter where you are, no matter where you're farming, it's just part of the deal. But significantly, and perhaps most significantly, is the fact there was zero, none, no evidence whatsoever indicating that if they relocated the ditch from the south part of Levison's property to the north part of Levison and the south part of Cage's property, that anything would change in terms of those inconvenient factors. You'd still have to maintain that ditch, you'd still have to clean the weeds, you'd still have a silt problem, you still have potential trash, and you still have potential flooding in those ditches. And that was the testimony from the only real farmer in the case, Denny Malachar.
Let me just ask a question about the burden of proof issue.
I'm sorry, Your Honor.
The burden of proof.
Burden of proof, yes, sir.
Who went first at the trial?
The plaintiffs went first in this case.
Did they object to that?
No, Your Honor, they did not object to that. We think that they assumed the issue of the burden of truth at the trial.
Was there like a case management order beforehand?
You know, there was a case management order, but I think the case management order was for the first judge that we had, and we came to the Court of Appeals.
Right.
And then we did it again, and I can't remember if there was a second case management order, but they clearly went first. And they assumed the burden of proof at trial, because they put on numerous witnesses, Mr. Ray, Mr. Brothers, Ms. Ray, that talked about the practicability and feasibility of the ditch. They put on numerous exhibits with regard to that, too.
They put on an expert witness, Brothers.
Yeah, Mr. Brothers.
And you
was their expert
or
witness.
somebody on your side cross-examined him and brought out these points you just made.
Exactly.
So by the time the plaintiff's case was over, all the evidence was pretty much in?
All the evidence was pretty much in, except for Mr. Cage's and Ms. Lovison's testimony, that they saw that property being irrigated to the top. But for example, the evidence exhibit 213, I believe it was, that showed the pictures, I believe that came in through Mr. Ray. So we had exhibits that they were able to, can get it done, it's feasible, get it to the top of their property, irrigate that 1.5 acres, but they irrigated with that little $500 pump, about 5 acres total, all above the driveway in this case.
If the court had ordered that the burden on this affirmative defense was on you, would any of the evidence have been any different than it actually was?
No, Your Honor, we would have put on Mr. Cage, we would have put on Ms. Levison, we would have called their expert witness as an adverse witness, because I took his deposition and he said it could be done. And so I'd have called him as an adverse witness, or I'd have read that deposition transcript into the record. I would have put on Mr. Ray as an adverse witness, or I would have read his deposition transcript into the record, and he would have testified that it could have been done, and in fact, it was done for the period of about 8 years straight.
So, Mr. Cage, let me direct you now to the pre-argument question that you
Right.
started off with, since you have 2.5 minutes. Hypothetically, because we're running short on time, let's assume that we disagree with you that it's a prevailing party fees clause situation here. What entitlement would you have under the statute to attorney's fees?
Under the first part, because that language is in both parts, part one, part. But under the first part, we've got a couple of cases well, first off, the statute specifically said if the court finds that the petitioner is not authorized by law to acquire real property through condemnation, it shall award attorney's fees. And there have been several cases interpreting that statute. Two in particular, the Billington versus Yost case, which is Court of Appeals case in 1989, and then the Platte River Powder versus Nelson case, which is a 1987 Court of Appeals case. And both of those cases talk about the fact that it's not just the ability or the standing to bring an action for condemnation that you're looking at. It's whether they complied with the entire legislative theme. And if they complied with the entire, and if they didn't comply with the entire legislative theme or scheme, then the condemnee should get attorney's fees. By analogy, and I am running out of time, but by analogy, there's a criminal case. It's called People versus Dunlap, 2009 Court of Appeals case, and it talks about, in a different context, in a criminal context, it talks about unauthorized by law. But again, it talks about the entire criminal scheme, the entire legislative scheme, and that's what they didn't comply with. They didn't have a burden, they didn't good faith bargain, and they didn't make an offer prior to this, and they didn't meet their burden of proof, and we think it was their burden of proof necessity, which this court defined as practical and feasible.
Do either of these two cases that you cited to us deal with the situation where they solely failed to show the feasibility or the necessity of the ditch?
Didn't deal with feasibility, no, Your Honor.
Okay.
It
Did
dealt
they
with,
deal-
for example, that second case dealt with whether or not they properly described the property that was to be taken, which is another element of the statutory scheme. But both of them showed you got to comply with the entire statutory scheme, which in this case would be practical and feasible, good faith negotiations, and an offer to purchase in cash.
So would it
prior
be your
to the deal.
position if we find that a good faith offer was never made prior to the bringing of the condemnation, that's a failure to comply with the statute, and that alone authorizes fees because that case is not authorized by law?
Yes.
Okay.
And we filed attorney's fees motion under both that and frivolous, and the second part of that statute allows it under the frivolous part too.
Thank you,
Your Honor.
counsel.
Sorry for running over.
It's all right. You have 4 minutes and 21 seconds.
Thank you. Good faith negotiations do not equal a cash offer. What has not been discussed is the plaintiff went first in this case because that was what was agreed to with the trial
Well, what's the
management.
authority for the point that good faith negotiations do not require a cash offer? I thought there's some case law that says good faith negotiations do require a cash offer.
Only if you're a municipality or government entity, then yes, I agree that it does. And I think, yes, if it's over $10,000, it may.
Why would it matter whether you're a municipality or a private landowner? It seems to me it's more of an imposition to say that a private landowner has the right of condemnation. That goes well beyond the historical right of government entities to exercise eminent domain.
Because the court cited 38-1-101 for that position, and that position under A1 is damaged by a state or political subdivision. That is not what through the plaintiff are. That's not what the plaintiff's case is about. Under Section C, it says nothing in this section shall affect the right of private property, right of a private party to condemn property as prescribed by law. This is the court mushed together different entities and different requirements by different entities, whereas this private party is not required to do that. I can find no case at all that requires a private party in a ditch condemnation case to make a monetary written cash offer. What I see is the case law that we've cited specifically says good faith negotiations and a failure to reach an agreement. And that happened clearly, and that's undisputed that that happened. What I was getting to previously as far as the plaintiff going first, that was discussed at the pretrial conference and agreed to because the plaintiff still has things that they have to prove. In other words, the new ditch they want has to still meet the statutory requirements. In other words, it has to be between the shortest practical route between the point of diversion to the point of use on the raised property. There were other prerequisites to condemnation that the raise needed to show that occurred. And this was all discussed and agreed to. The plaintiff raised this burden of proof issue in all of their briefs that were filed with the trial court. And it was agreed at that time that plaintiff would go ahead and go first because they still had issues to prove, and that we were going to get through this trial in 4 days, which we did.
Before you run out of time, could you address what Judge Roman asked and what's the subject of the court's pre-argument order?
Yes, Your Honor. I think being authorized by law means two things. One, who you are, and two, what you seek. That is, a person without access, being who they are, who seeks an access easement. A government entity, being who they are, seeks property for a public purpose. A owner of a water right, being who they are, seeking a ditch. All of the case law falls into those categories, who they are and what they are seeking to condemn. And that's what the statute was designed to protect, so that a person who had access could not, who did not have access could not seek a ditch easement, if that makes sense. What the defendants have tried to do, and the court, I think, did also at other times in this case, push together access cases with ditch cases. There's a difference. Where they come from, the purpose, the rights. The Constitution says all persons and corporations shall have right-of-way across public, private, or corporate lands for the construction of ditches, canals, and fumes. Ditches, canals, and fumes, not just a ditch, not a single ditch, but it can be multiple, whereas access cases, you have a right to an access easement for one access. That is usually all you get. But it can be, but it is who you are and what you are seeking, those two things. Clearly, this was designed so that somebody who did not have what they needed, or they were the wrong person to bring this type of case, could be disposed of early and ended before litigation, before trial, before years of whatever it is. This was an early procedure to get something out and to award attorney's fees. That's not what you have here in this case.
If we disagree with you and conclude that a good faith offer, monetary offer is required before bringing a condemnation, does that render your case not authorized by law?
If the court were to make new law, I do not agree that that would be not authorized by law, because we are a person with water shares. By Constitution, we are a person authorized by law seeking what the Constitution allows for us.
Thank you, counsel.
Thank you.
Thanks to both counsel for your fine arguments. The case stands submitted. An opinion will issue in due course. Counsel are excused, and counsel in the next case may advance to the podiums. The next case on our docket is called Avenue Capital Management versus Shaden. Counsel for appellants, you may enter your appearance and proceed.
Good morning, Your Honors. Alan Lanstra on behalf of the plaintiffs' appellants. Your Honors, the district court erroneously dismissed the complaint in this action. The plain language of 3B, which is the exculpatory clause, demonstrates that the claims alleged are not exculpated by Section 3B. To be exculpated, a claim must be based on acts relating to both the restructuring and the transactions contemplated by the restructuring agreement, which, by their own terms, can only be transactions after the restructuring agreement. The plaintiff's allegations concern fraudulent misrepresentations to induce plaintiffs into the restructuring agreement, which misrepresentations occurred in the offering memorandum, which was presented by the defendants the same day as the restructuring agreement. The district court looked past the language of 3B and just adopted the defendant's argument that 3B applies to anything related to the restructuring. If we look at the language of 3B, the important language, and break it down just like we would a statute, you'll see that it covers and provides exculpation for, one, any act or admission in connection with or arising out of A, the restructuring.
There's no A there, you're just inserting that.
You're right, Your Honor. I'm inserting it to break it down so that we can understand.
Mr. Leinster, is there some practice standard that requires release provisions to be written in a totally incomprehensible way?
Your Honor, I'm a litigator, I'm not a draftsman, so I haven't been involved in how these deals are written. I don't think so. I think that there are many drafters involved in this type of a process, and they may not be as clean as perhaps a litigator would draft them. I don't think that the release is incomprehensible, or being A or B, 3A.
Well, let me
3B.
drill down for a moment, if I may. In 3A, there's what I recall as a fairly typical provision that says, there are all these releases, but we're not releasing the obligations of the actual documents that are part of the deal, because that would make no sense to say we're releasing the obligations under the very documents that constitute the deal. No one would do that. But no corresponding carve-out is in 3B. Do you know why?
Well, I think that the only way to reconcile the two provisions, Your Honor, is 3A applies to a different time period than 3B. I do think that if you look at 3A and you look at the language of it, it will show you that the time period is preceding the restructuring agreement, which is December 2011. So there may have been acts, there may have been things that ran to the restructuring of the restructuring agreement that
It was
preceded.
prior to the effective date, which is, I think, December something, 2011, right?
December 23rd,
Right.
2011,
But the
correct.
closing on this deal, the closing of all these documents occurred after that date, did it not?
Correct.
Right. And that's what this whole document's about, because this was entered into in January.
I do agree that the
Yeah,
AARA
yeah.
is signed on January 24th, 2012. I don't agree that it is talking only about the closing. I think that 3A is talking about the period that preceded the restructuring agreement.
Right.
So what happens in this instance is the defendants issue an offering memorandum. We don't sign that offering memorandum. They set forth the terms of what they're proposing. Then in the restructuring agreement, the parties sign the restructuring agreement. That is also, Your Honor, on December 23rd, 2011.
Mm-hmm.
And the parties agree that there are certain options, there are things that you can do, and there's going to be a closing in a month. There are obligations under the restructuring agreement. There are things that both the plaintiffs and the defendants have to do. On January 24th, the closing occurs or it doesn't occur. In this instance, there was a closing of an out-of-court restructuring. At that time, at the time of the closing, the parties entered the assignment, assumption, and release agreement, in addition to other documents.
So as of the closing date, or after the closing date, were there executory obligations by either party? In other words, obligations under the deal that had not yet been consummated?
Well, there would have been obligations. I'd have to go back or read the further brief. There certainly would be obligations of things going forward. Agreement to provide certain documents, agreement to transfer stores, whatever was contemplated.
I mean, clearly there was no intention to release those obligations, was there?
Well, 3A, I don't think speaks to that.
No, but
3B,
3B.
Yeah, well, yes, I think they do. I think 3B is contemplated to release, not the obligations, but claims
But
from
where
that.
does it say that? I mean, where, under your understanding of 3, well, I guess that's a question more properly asked of your opponent. I mean, it just seems to me that if 3B releases everything on a going forward basis, including obligations under the deal, that can't be the right interpretation of 3B.
Well, it doesn't release your-
Doesn't make any sense.
Well, it doesn't release every obligation. That's not the purpose of it. It's just like an exculpation clause. There are many different kinds of limitations of liability. We cited in the brief examples of you go to a water park, and before your son or daughter can ride a ride, you need to sign a limitation of liability. It doesn't mean that suddenly the water park has no obligations. It means you've released or capped some of your liabilities going forward. That's an exculpation clause. We see those in state laws regarding the duties of directors. There certainly are instances where, looking ahead, the parties can agree that one side of the party, or both in this instance, are not going to be sued.
And so I want to go back for a second instead of looking ahead. So temporally then, when we look at it and we look at 3A, your argument is that it happened prior to the restructuring, and so 3A should apply, and specifically the unlawful conduct provision? Is that where you're
Yes, Your
hanging
Honor,
your hat?
but let me tweak your response to prior to the restructuring agreement. So the restructuring agreement is dated December 23rd, 2011. Again, that's the document where the parties have agreed, we're going to take these steps towards a closing. So it is on the date of the restructuring agreement that anything before that is applicable to 3A. The restructuring is a much broader definition, I think, in fairness. The restructuring agreement is a document signed on December 23rd, 2011.
And what in 3B tells us that 3B does not apply to an alleged fraud that induced the restructuring agreement itself?
Well, a couple of things. In the text of 3B, I do think, and this is, Your Honor, where I was going back.
Yes,
I'm trying
go back
to
to A.
insert
Yeah, go
subsections
insert A,
just for
okay.
digestion. The contractual clause in 3B talks about for any act or omission in connection with or arising out of, and these are my insertions, A, the restructuring, and B, the transactions contemplated by the RSA. So a transaction contemplated by the RSA must follow the RSA. That's the only thing that makes sense to us. The restructuring is a broader phrase. But
Okay,
again,
let's take A, an act or omission arising out of the restructuring.
yes,
In connection with the restructuring, there was an offering memorandum. You alleged had false statements or omissions.
Yes.
Doesn't that arise out of the restructuring?
Yes.
And isn't that released?
yes, I agree. But the problem is that the phrase says for any act or omission in connection with arising out of the restructuring and the transactions contemplated by the RSA. The offering memorandum is not a transaction contemplated by the RSA. It was delivered the same day. It's frankly not even a transaction. The offering memorandum is a memorandum given by the defendants.
And we're down to is whether and means and or and means
I think that's
plus or
part, I think that's part of it.
So what law is there that you have, that New York law, because that's what governs this, that says a contract that uses "and" means "and" only and not "and" or? Just
Well-
the two cases you cited in your brief?
Well, yes, I would disagree that "and" always means "and."
Okay.
I think we would all agree, we've all interpreted enough statutes and contracts to say that in certain instances,
Right.
lists or whatever,
Right.
that this is not a list. These are conditions for a release.
Can you,
Go ahead,
can you
Your Honor.
tell me exactly what you were asking us to do?
Reverse and remand.
I know, but with instructions, are you asking us to determine as a matter of law that this release does not bar your claim? Or you're asking us to send it back with a legal determination that it's ambiguous and therefore the fact finder has to determine the legal meaning of the release? What exactly should we do?
Well, I think it's unambiguous to me that these claims are not waived, are not released by 3B or 3A. So that would be my order. The alternative order would be it's ambiguous and the fact finder should decide. I also think, because I feel this certain way about 3B and its interpretation, that the interpretation of 3A is incorrect by the court, that unlawful acts are not applicable here. And at a minimum, I think the district court should have looked at the complaint to determine whether or not unlawful acts or criminal liability were sufficiently alleged. I think the 12b-5 standard expects that.
So let me take that apart for a moment. If we disagree with you, and we think that "and" really means "and" or, that is, it either is in connection with the restructuring or with the transactions afterwards, we disagree with your reading of 3B, that would release these claims, would it not?
I think that's true.
Then we wouldn't even need to deal with 3A, because 3B alone would release these claims.
Well, yes, but I would prefer not that convenience. I do believe 3B means "and."
I'm trying to get you to help me define our task.
Yeah, well, I
If
think
we
the task starts with 3B in that language. I mean, I will tell you, in that section, the words "and" "or" are being used. "And" in certain instances, and "or." And we know from principles interpretation that maybe in a list or something, "and" could mean "or." I don't think that's fair when we're talking about conditions. And I don't think it's fair when we're talking about a section that is talking about, that is using the words "and" in other instances, "or."
You talk about conditions, and you seem to be saying that a kind of a different rule of construction applies to a condition, and I'm curious if you have any authority that makes that distinction?
I don't know that we cited any in the brief. We could certainly supplement. I do think, as a matter of interpretation, I think the basic rule is that "and" means "and." I don't think under New York law "or" means "and." I don't think that makes any sense, and I don't think any of the states or the federal courts hold that. I think there can be instances where "and" could be interpreted as "or." I think the most common instance is when we're talking about a list. This is not a list, though. Whether it's condition or release, that's not what's happening here. I don't believe that this is a list like mussels or shellfish, as cited in the case that the court identified. The defendants identified.
Does that case make any sense at all?
I'll let counsel address that. I don't think there's enough there. I think we would all agree. There's 2 paragraphs of analysis. So I don't agree that "and" means "or" in most cases. I think you start with the language. And I think those are principles of interpretation. Your Honors, I'd like to reserve my last a little bit over a minute for rebuttal, if you don't mind.
Thank you, counsel.
Good morning, Your Honors. My name is Nathaniel Garrett. I represent the appellees, and I'm appearing pro hoc vice. I'd like to start with one overarching observation and then answer Judge Berger's question about what context tells us about the meaning of these provisions. The overarching observation is that you've heard today, as in the briefs, that Section 3B doesn't apply because the transactions contemplated by the RSA occurred after the offering memorandum. and that they're not suing over the transactions contemplated by the RSA. The fatal flaw in that argument is 3B doesn't release claims based on the transactions contemplated by the RSA. It bars claims based on any act or omission, regardless of when they occurred, relating to the restructuring and the transactions contemplated by the RSA. If you look at 449 of the court file, 446 to 449 of the court file lists the transactions contemplated by the RSA. These were the steps necessary to finalize the transaction that they had been negotiating for months. And at 449, it says these transactions will be implemented pursuant to the offering memorandum and the other documents. If a transaction is implemented pursuant to a document, the document relates to the transactions. So why does 3B only have one exception when 3A has 5? Judge Berger asked, do lawyers like drafting nonsensical releases or something to that effect? No, but this is a reorganization case, and that's the context. If you look at 356 to 357 of the court file, you will see that in addition to negotiating an out-of-court transaction, the parties were contemplating an in-court prepackaged bankruptcy because they didn't know if this reorganization had to happen in court or out of court. So before the AARA, before the release was drafted, they drafted a release for the bankruptcy. Well, how do these releases work in bankruptcy? They work this way. You have one section called a release, which is focused on putting a clean slate before acts that occurred before a certain date, and you have an exculpation clause, which in reorganization context means you release acts related to the reorganization. One is temporally focused, one is focused on subject matter. And sure, as in the Holmes case, which we cite, there is sometimes a temporal overlap, but they're there to do different things. Now, 3A, Judge Berger, you said there were no exceptions in 3B. That's wrong. 3A has 5 exceptions. The parties explicitly took one of those exceptions and moved it into 3B, an exception for so-called assumed agreements. So it's clear the parties did think, here's 3A, we have this broad release for everything related to the restructuring or otherwise before the effective date of the RSA. Well, that goes back years. We're concerned about that. We want certain exceptions. 3B is much more specific. It's just related to the acts related to the process of reorganization. So they said, this process we really want to leave alone. We're only going to adopt one of the 5 exceptions. That tells you they intentionally did not want the unlawful acts exception to apply. Judge,
That's you're referring to the last proviso?
Correct.
3B?
Yes, Your Honor.
Provided that this exculpation shall not adversely affect QCE and the indemnities with respect to the rights and obligations arising from the assumed agreements.
Correct, and that's one of the
tell me again,
exceptions in 3A.
What's the significance of that?
The significance of that, Your Honor, is that the parties looked at the 5 exceptions in 3A, and that was one of them, and they said, this is the only one we want to carry over into 3B, which is the clause looking at the acts related to reorganization. So we don't want other exceptions, and my explanation is, why would they do that? Well, because Section 3A was reaching back years. Remember, these creditors, these hedge funds were in the credit debt structure going back to 2006. So there was a lot of history here.
You're kind of speculating I assume you weren't one of the deal lawyers.
No, Your Honor.
So you're speculating as to what people thought or didn't think,
Here,
because there's nothing in the record at this stage about that.
and I'm not trying to get into what the parties contemplated. All I'm saying is, under New York law, clauses should be enforced as written. And what plaintiffs are asking you to do is to rewrite Section 3B to say it only applies after a certain date. I must say that's rather bizarre, because they're not actually saying it's only a prospective clause. If it was only a prospective clause, given that it was signed in January 2012, it would only go forward. They're actually saying, well, it's partially retroactive because it goes back to December 23rd, 2011, but not all the way retroactive. It ends on the date the allegedly fraudulent statements were made. That's a bizarre interpretation and not supported by the language, which says it bars any act or omission or any obligation arising under the RSA. And Judge Berger, you asked about that clause. Well, what are the obligations arising under the RSA? At page 455 of the court file, the number one obligation, the primary obligation of the defendants, was to prepare the offering memorandum. That was their obligation, and their only response to that is, well, Section 3B means ongoing obligations.
Let me ask you this. We've got a whole bunch of really high-powered lawyers in this case who are taking very different positions as to the meaning of this thing. I know it's not dispositive, but doesn't that send a pretty good signal that at a minimum, this thing is ambiguous?
Not when our argument is enforced according to its plain language, and their argument is rewrite the provision to only apply on a going forward basis.
But counsel, does it make any difference that it's a motion to dismiss ruling? And so if it's incomprehensible, as I've heard used, or ambiguous, why not send it back for fact-finding?
Well, I think both parties, I heard plaintiff's counsel say it is unambiguous. We agree. There's no ambiguity in the provision about whether 3B applies on December 23rd, 2011. It actually, the language is unambiguous. The only question and the only argument is whether 3A is somehow rendered absurd if you enforce it according to its plain language. Now, I have a response to that, but it's not ambiguity. They're actually asking you to rewrite the provision to say something it doesn't say. We're not talking about we don't understand the language of any act or omission or any obligation. That's unambiguous. The question is whether this court needs to rewrite it because 3A would somehow be a meaningless provision.
So you're saying, you think your opponent is conceding that 3B does apply, but we should say it shouldn't apply because then it would completely make 3A meaningless?
I think there are two arguments. The first is that 3B doesn't apply because the offering memorandum was not related to the transactions contemplated by the RSA. I've already addressed that argument. I think the second argument is if it does, then you have to rewrite 3B, because if you apply it back on December 23rd, 2011, 3A is rendered meaningless. And I think there are, I feel like I confused Judge Richmond with that. Let me make sure I'm.
I thought he was saying that 3A applies to acts that occurred before the execution date. 3B applies to acts that occurred, a broader category of acts, not just those that occurred before, but those that occurred before or after, but relate to the restructuring.
No, I think you flipped the arguments, Your Honor. Their argument is that 3A applies to acts or occurrences or transactions before December 23rd,
Yes.
2011.
That's what I meant to say.
And this court should therefore infer that 3B only applies after, even that's not what it says.
Right.
What we're saying is it's far from unusual and not inappropriate for parties to have two releases which overlap somewhat in terms of time period.
Right.
That
These-
happens all the time.
These do overlap, and the difference is that although they overlap with respect to transactions before that date, B also covers transactions in connection with the restructuring which occurred in January.
Exactly, Your
Okay.
Honor. Because 3B was really the clause. If you look at 356 to 357, which is the bankruptcy, I was talking about how they drafted releases for an in-court bankruptcy. You will see they modeled this release on that language. And as I said, in reorganization procedures, that's what these two sections do. The first one is essentially clearing the decks before a certain date. The other is a release for acts related to the reorganization. And as in the Holmes case, which we cite, yes, sometimes an act is doubly barred. But that's not unusual or wrong. It's just that it's doubly barred. And we're saying these clauses ended up playing the same role.
Do you agree if we find 3B applies, we don't even need to address 3A?
Yes.
Do you think, under your interpretation of 3B, does it make any difference what "and" means?
No.
Can you tell me why?
Sure, because we win either way. Because if and means and, as I said, the transactions contemplated by the RSA are at 446 to 449. They were the final transactions necessary to consummate the transaction. And at 449, the RSA explains these transactions are to be implemented pursuant to the offering memorandum. They're trying to split the transactions from everything that came before. It's an artificial distinction. This was a negotiation between some of the most sophisticated hedge funds in the world and the company for months over the terms of the agreement. They came to a negotiation over the terms, they put it in the offering memorandum, the creditors voted, and then they had to take certain actions after that to consummate it. But of course, those transactions related back to the offering memorandum that was discussing the transaction and setting forth its terms. There is a relationship. And again, I just want to return to where I started. The fundamental argument is 3B doesn't apply because we're not suing over the transactions. That's not what the clause says. It says any act or omission related to that transaction. And these statements obviously were.
It says arising out of.
Well, yes.
And what are the transactions contemplated by it? You're saying the transactions contemplated by it are the closing of the restructuring.
Well, the restructuring support agreement lists, I mean, the helpful thing is the restructuring support agreement uses the same terms as this document. It says these are the transactions.
446 to
446 to
449.
449. It was things like the second lien debt holders exchanging their debt for equity, the first lien holders getting paid back. It was the final step in the process. But again, those were pursuant to the offering memorandum. And as I said before, it says any obligation. On 455, the RSA uses the term, here are your obligations, prepare the offering memorandum. That's the obligation. So again, 3A is not rendered absurd. It was serving a different purpose. These were extremely sophisticated parties with extremely sophisticated lawyers, and they intentionally did not include the unlawful carve-out in Section 3B because this was a contentious proceeding, and they just said, we're leaving this process behind us. We'll have carve-outs for what happened 4 years ago or 5 years ago, but as to this, we're done. We're moving on.
And this does have a future-looking component, doesn't it? Because then it goes on to say, or the renegotiation of executory contracts and leases, which
Your
would
Honor-
have happened after.
Your Honor, the funny thing is both clauses apply forward. Section 3A talks about releasing any act taken by the parties in essentially their official capacities. It has no temporal limitation. It was retrospective and prospective. So was 3B. They were just trying to focus on different things, and 3B was the more specific to say, look, 3A is a pretty good release, but we're going to have some exceptions. But 3B, as to what's gone on in the last few months, we're done. We're moving on.
Can you give me an example of some hypothetical event that would be released by 3A but not by 3B?
Sure, we gave one. So let's say that in 2012, the CEO and CFO negotiate a merger or something like that, and Avenue and Fortress, who were senior debt holders, come in and sue them and say, as shareholders, you've breached your fiduciary duties in this merger, et cetera. Well, that's covered by 3A. It's an act that the
Wait,
CEO...
you said 2012, that's too
No,
late.
I'm sorry, I'm sorry.
meant 2010.
Yes, sorry. I was trying to give just a hypothetical date that doesn't matter, but 2010. There's a merger, it goes wrong, the CEO breached his fiduciary duties. Okay, 3A comes into play. That occurred in their official positions, it occurred before the RSA. 3B, totally irrelevant. Unless there are questions on 3A, as Judge Richmond said, our position is that the court need not address 3A. I think there's one last thing I'd like to say. I've tried to explain why 3A and 3B don't conflict. I haven't talked about the Chentro case, which is New York's highest court. The argument that, there were two arguments that feature here that were made in that case and rejected. Recall, in that case, the plaintiffs entered into two releases that had the same language. I mean, different than this case. It actually had the same language, claims arising from...
But it excluded fraudulent conduct.
Exactly. One did.
Yeah.
The second one didn't. And so the plaintiffs made two arguments that are made here. Number one, you should read that fraud clause into the second provision. That was actually argued before. It's not being argued now. And the second argument was, why would we have that first release? It's meaningless if we have the second release with the same language without a fraud carve-out. And the Court of Appeals said, look, you're represented by lawyers, you're very sophisticated, you know what you're doing, we're going to enforce the plain language. And I know the argument was made that there's a dispute over what really happened in Chentro. All I can say is, watching the oral arguments in that case, it featured prominently this argument about why do you have two releases that cover the exact same thing? One has a fraud carve-out, one doesn't. My only point is, even if there was a conflict between 3A and 3B, which there's not, Section 3B says this clause is in addition to and not in limitation of any other release. So we think you would still apply 3B.
We better go to unlawful acts for your last 58 seconds.
Sure.
Why would unlawful acts be limited to criminal conduct? Or how would it work if that's what it was limited to?
So we're not suggesting for purposes of this appeal there has to be a criminal indictment. What we're saying is unlawful acts has one of two meanings. It either means any civil or criminal violation or criminally punishable. As the district court held, the first dictionary interpretation would render the release a non-release. It can't be that. Plaintiffs don't really dispute that position. Instead, they say, well, we have our own definition, which is some civil acts and not others. But that's a gerrymandered interpretation that's not anywhere in the dictionaries. And so it must mean criminally punishable. So at the very least, what they have to do is allege acts that would be punishable under the penal code. And that argument...
Aren't the violations of the Colorado Securities Act punishable under the Colorado Criminal Code?
This is exactly my waiver point, Your Honor. A willful violation under the CSA, may I finish my answer?
Yes,
A
please.
willful violation
We'll give
under the
them extra
CSA
time.
is a criminal act. We've litigated for years whether the CSA applies at all because, as the federal court held in a prior iteration, securities laws don't apply. If they had argued, yeah, we allege a criminal violation of the CSA, and that's why the unlawful acts carve-out applies, the court would have been forced to answer the issue we briefed, which is whether the CSA applies at all because we're dealing with a security. That's my waiver point. They didn't make the argument,
If
so
we
the
look
court
in their
never got
amended complaint, we will not find any language that said that the defendants willfully violated the CSA. That's your point?
Well, no, I'm making a different point. I'm focused on the briefing in the district court at 873 to 874
Well,
of the
does
court
the
file.
complaint allege willful violations of the CSA?
I don't know off the top of my
All
head,
right,
Your
we'll
Honor.
check it. Go ahead, make your point about that.
Well, my point is that the issue for waiver is whether the plaintiffs gave the trial court a reasonable opportunity to rule on the issue. They made 3 arguments, 873 to 874 of the court file. Court addressed every single one. They didn't cite a penal statute. They didn't say this is a violation of the willful provisions of the CSA. So he didn't feel like he had to address whether the CSA applied because he found it meant criminal, and they didn't have an argument as to why they'd alleged criminal conduct.
He also found that the CSA waiver does not preclude their case. There's the statutory language that says you can't waive the CSA. He found that's not applicable to bar their claims. So, but they don't raise that on appeal, by the way, right?
No, no.
That's not here, that's not before us.
No.
It isn't just about any garden variety fraud. I mean, if you had an aggressive prosecutor, wouldn't it violate the federal mail and wire fraud statute?
I haven't thought about the mail and wire fraud statute, to be completely honest with you, Your Honor. I have, the interesting thing is, in Colorado, garden variety fraud is not a crime. They have certain kinds of fraud that are.
But it doesn't say unlawful under Colorado law.
No, that's fair. I was just making the point that I focused on Colorado and New York law. I haven't focused on the mail and wire fraud statutes, in part because it wasn't argued, but I don't have an answer.
So your answer to the unlawful act part is that they never argued to the trial court that the conduct they allege amounts to a willful violation of the CSA.
They never argued it was a criminal violation of any statute, a violation of any criminal statute.
Okay, thank you. Counsel, thank you. Whatever time you had before, maybe the clerks will add 2 minutes and 25 seconds to that to be even up.
Thank you,
Okay?
Your Honor.
Let's see if they can get that.
Let me start where he just ended off. We didn't waive that argument. Fraud is a crime. I think that below, the argument was we alleged unlawful conduct. And we defined unlawful conduct one way, and the defendants defined it another way. To suggest that we are taking the position that fraud is not a crime, and that we didn't allege fraud as a crime, and thus we waived it, that makes no sense to me. We argued the issue below. Frankly, the defendants below did not argue that fraud was not a crime. I'm not taking the position that they waived that on appeal. We argued it was unlawful. I want to go back to
Wait
three.
a second. What then is unlawful acts under this document?
Well,
You say in your brief, it's not limited, it's not every civil wrong, because you acknowledge it's not breach of contract, it's not negligence, it may or may not be patent, I can't
Right.
remember.
Right.
Fiduciary duty, but it is fraud.
Yeah.
What's the meaningful, principled rule that will allow that distinction to be made based on the language in this document?
Well, let me start by probably an answer you won't like, is that this court only needs to determine whether fraud or conspiracy to fraud are unlawful. I think that's clear. I don't think we need to define the whole thing, just like we wouldn't have to define gross misconduct or willful conduct, or gross negligence or willful misconduct. I don't think normal, regular breach of contract is unlawful. There's efficient breach, there's economic breach all the time. I don't think simple negligence is either. There's a reason that unlawful acts is in there.
Is it
We're
intentional
acquiring
torts? Is it intentional torts? Is that what you're saying it means?
I wouldn't limit it to intentional torts. I think it's whatever unlawful means. But for here, I think fraud and conspiracy to fraud are clearly unlawful. And I don't think you've heard the defendants say otherwise. I don't think you could. The issue would come down to our pleading, and at a minimum, we should have been afforded the opportunity to amend our complaint to list statutes that the district court claimed we needed to. I want to go back to 3 and 3B because this is really important. It's important that they have to be reconciled. When you have one agreement, 3A and 3B have to be reconciled. What's interesting about 3A is if you look at the language of 3A, it covers, quote, arising out of the restructuring.
Why does it have to be reconciled? I mean, as I recall, if I was representing a party that wanted the end of dealings with the other side, they would write and put in as many releases as they possibly could. I would. And even if they were one overlapped the other, who cares? Why do we have to reconcile?
Well, one, our interpretation gives them both meaning, and we think the actual text gives them separate meanings. I don't think the intent was to overlap. I don't think sophisticated parties decide to write 3A, and then in 3B, the very next page, completely overrule it and render it nugatory. The central case is completely different. Those are two different releases for two different agreements. This is the same document, and we always read a contract or a statute as a whole, and that's why it has to be reconciled.
You're correct, though. You started to say before Judge Berger asked his question that this does cover conduct arising out of the restructuring. It does.
Agreed.
3A does,
Agree, subject to,
subject to all those exceptions.
and the most important one being unlawful acts.
But the language that arising out of the restructuring and then all the exceptions is preceded by an or, which released, and the prior language releases any acts prior to the effective date in any way related to them, which could be a fraud that occurred in 2010.
Subject to the unlawful acts exception. I don't disagree, Your Honor. I don't disagree that arising out of the restructuring. I read it myself. It's in 3A. But it is subject to unlawful acts exclusion. I agree. I also think 3A is limited in time. The other thing is if you look at exception 5, exclusion number 5, it says, owed to the released or releasing parties or any obligation arising under the RSA or an agreement entered in pursuant to contemplated by the RSA. It is excluding that, and defendants are then in 3B saying, forget what we said in exclusion 5. It's released.
But why didn't they put that in 3B?
Because it's in 3A, and 3A means something different. It's directed at a different time period than 3B. If I could very briefly just,
Actually, your time is up, counsel, so.
Thank you, Your Honors.
Otherwise, we can go on forever with this fascinating case.
we definitely could.
But I think we have to allow the other parties time to argue their case. Counsel, thanks to both of you for very fine arguments. The case will stand submitted. An opinion will be issued in due course.
Thank you, Your Honors.
All right, let's do this. Why don't the counsel come up? We're going to take a quick recess for, or a 5-minute recess, okay?
The court will be in recess.
Morning docket. In the marriage of Safley and Ziraxeta. Ziraxeta? I'm not sure I'm pronouncing that right. I don't know if council were present, probably not, when we made our earlier announcements. For anybody in the audience, please turn down your cell phones or electronic devices. Council will have 15 minutes to argue the case. You may reserve, appellant may reserve time, but you're on your own to reserve as much time as you want. There's a clock up there. We're not going to give you a hand signal. Please stay close to the podium because this is being recorded. And I don't know if this is a case where the privacy of individuals such as the children may have to be preserved. If so, please use just initials and make it clear that you're talking about children or somebody, anybody else whose privacy might be at issue. We try to protect that. And with that, counsel for the appellant may proceed.
Good morning. May it please the court. I'm Mark Kaplan with Paige Mackey Murray as co-counsel on behalf of the appellant mother. I'd like to first address the written question that was submitted by the court. First part of that was, what legal support is there for restricting mother from attending the children's doctor's appointments? It's our position there is no legal authority for that. This was a modification of decision-making case, and education and medical decisions were modified. Decision-making has been held by In re the Marriage of Schenck to address, and that's 39p3 1250. In that case, it held that sole custody merely provides, in this case, the mother, with the ultimate ability to resolve disputes as she sees fit. It is a way to resolve a tie, so to speak. Who's going to make this decision? If you have joint decision-making, somehow you have a tie if you don't agree. It is not meant to invade a parent's right to attend medical appointments. It is.
But why? I mean, if the court finds unsupporting evidence that the mother's attendance at the medical appointments is likely going to harm the child, why doesn't that fall within the court's broad discretion to make these types of orders?
If that evidence were there, hypothetically, because as you know, we don't admit that that evidence exists, there are ways a court can enter orders that address that situation, but not in the context of a modification of decision-making. There is a statute, 1410-129, that deals with modification of parenting times. Subsection 4 deals with a motion, what we typically call a motion to restrict, which says that a parent can ask the court to restrict a parent's parenting time when the motion alleges that the child is in imminent physical or emotional danger due to the parenting time or contact by the parent. So there is a mechanism to deal with those types of situations. A court always has the right to protect the child from harm, but not in the context of a motion to modify decision-making. Furthermore, as you know, we are alleging that there is a fundamental constitutional right under the Troxel decision, under a number of decisions in this court, in re the marriage of Newell, in re the marriage of Mixoud, in re the marriage of Dean, in re the marriage of Cheslock, all have extended Troxel to various situations. Travel in Cheslock, religious decision-making in Mixoud, freedom of speech in the context of medical care in Newell, in Dean in terms of disciplining a child. All those decisions have said that if there is actual harm, that the court can act. It has to apply strict scrutiny because we're talking about a 14th Amendment right of due process, or in the case of Newell, a First Amendment right of free speech, or Mixoud, a First Amendment right of freedom of religion, expression of religion. But there are limits to fundamental constitutional rights. And even Troxel, the U.S. Supreme Court has said in Troxel that if there is a compelling state interest and you use strict scrutiny, and that the harm is specific and in detail, which we've said in our cases as well. And you're using the least detrimental alternative. If you go through that analysis, what I call the strict scrutiny or constitutional analysis, then a court can intervene when you have the type of harm, Judge Berger, that you're talking about.
There's no finding of danger on the part of the mother in this case. There's no finding in this case of
That's
dangerousness.
exactly right.
And there had been no motion to restrict parenting time.
Correct.
So I guess what you're suggesting is if we were to agree with you on that point, that preventing the mother from attending the medical appointments was error, we would send it back for a modification of the order?
My position is that you would just simply strike that order, that omnibus order, saying it was without authority.
That part of the order.
That part of the order.
But the other parent could go back to court and file a motion to restrict parenting time on this basis, and then the court can make the appropriate findings.
Yeah, if there's evidence to support a motion, then a parent always has that ability to do that. In this case, I think the judge was clearly upset with what he perceived to be conflict between the parents rather than harm to the children. And he felt, and he actually expressly stated in his decision, I'm really doing this to minimize their contact. And
But wasn't there evidence, at least an opinion from the PRE, that conflict actually was harming the children? Not only had in the past, but would in the future?
the PRE gave an opinion that that it would most certainly cause distress, that the conflict would cause distress. Not that the appointments, not that the scheduling of appointments or the attendance of appointments would cause conflict, not that, or harm, or not that attending or scheduling medical appointments would somehow endanger their physical health or impairs their emotional development. We never got to that level. All he simply said was, conflict has to hurt these children. And I understand that concept, and I understand the judge being concerned about conflict, but there are certainly less detrimental means of handling conflict. You know, in this case, the judge went further than just dealing with the medical appointments, and he actually took away mothers' right to have joint decision-making in the area of education. Yet the judge imposed certain restrictions that helped to eliminate or alleviate the conflict, such as, you know, directions about only saying the things that need to be said in communications and trying to avoid other types of conflict. So he gave them a blueprint, if you will, of how to minimize conflict to avoid what could be harmful to the children. So
let me ask you this then, in
Yes.
terms of what could be harmful to the children. Would potential for harm be enough?
potential
For harm to
of,
the children?
well, harm, no. Potential endangerment in terms of potentially endangering physical health, yes. Doesn't have to be actual, could be potentially, because it says would endanger, okay? The emotional development, though, it says impairs. So as I read the statute, and as I believe the statute's been interpreted, that requires actual impairment of emotional development. But potential physical harm, or physical harm would be sufficient. Here, we don't have any evidence of what's missing here is the evidence of the harm. So we also are arguing the abuse of discretion in the judge making the conclusion that this is harmful. Now, Judge Richmond, I agree with you, he never went further than that and said, I'm going to find endangerment in terms of physical health or impairment of emotional development. And he never weighed whether the benefit of the change outweighs the detriment, which is a requirement under the modification statute as well and the endangerment standard. So the judge, even though he said there's harm, and even though the PRE said, I'm worried that there's conflict, and conflict always causes, or usually causes, emotional distress, that's not the specific type of harm that is required under our cases. We need substantial harm that's in detail, and we need to have the court make a finding that this particular harm is the type of harm that results in endangerment. Because as it's been held in many of our cases, general harm is not enough. it has to be the type of harm resulting from this type of conduct that results in the endangerment.
Now, when you make that statement, are you relying on constitutional principles, or are you just interpreting the statute, or both?
I'm relying primarily on constitutional principles. Those are, that's language that we have in all the cases that I cited before that really deal with the constitutional analysis.
Aren't there cases, though, from this court that say the constitutional principles have no application in this context, where we are not talking about a termination of parental rights, we're not even talking about a de facto termination of rights where one parent gets a custody order that basically gives them sole custody? This is a long way from that.
I don't know if it's a long way from that. I mean, we do have cases which say that the constitutional analysis doesn't apply to the normal type of parenting decisions. But what
You're not challenging those cases.
No, I'm not challenging those cases. I'm trying to give effect to all those cases. Unless the court has an immediate question, I'd like to reserve the remainder of my
I
time.
have one more question. Looking at the PRE and the court's credibility findings, the court found the PRE to be credible, the father to be credible, the mother to not be credible. Unless it was clearly erroneous, doesn't that tie our hands a little bit up on appeal?
I don't believe so. In the second order, the judge found neither affidavit of the parties to be, frankly, of any help or beneficial, I think is the word he used. So in essence, he was saying neither one of them are particularly credible when it comes to the restriction of attending medical care and scheduling medical appointments. In terms of the original order, you're right. The judge found my client to be incredible, but nonetheless, the judge didn't have any facts in its order or in the record itself showing actual harm. We had the therapist for the children saying the children are not harmed. We had fathers saying the children are not harmed. But no one actually said the children are being harmed. All we have is what Judge Berger referred to, which is the concern of the PRE that, well, conflicts is going to cause harm. That's not evidence. So even without my client's testimony being credible, I don't believe the record is sufficient to affirm the findings of the court.
Counselor Appellee?
Good morning, Your Honors, and may it please the Court. I'm Catherine Lum, registration number 45716. I represent the appellee, Dr. Zaraxida. With me at counsel table is Mary Moses, 25945. I want to first address this Court's question issued prior to today's arguments about the order prohibiting mother from attending the children's doctor's appointments. The provision is a reasonable and limited one that can be supported by a best interest finding alone and does not require a findings of evidence or endangerment. 1410-124-7 provides the court with the legal authority to enter any orders regarding parental responsibilities that are in the best interests of the child. Likewise, 1410-129 provides the court the ability to modify a parental responsibilities order whenever that modification would be in the best interests of the child. The court in this case entered a lot of other orders that didn't have to do with decision-making that mother is not complaining about here.
Well, why would that matter, just because she's not complaining about some?
Well,
She
because
is complaining about this one.
Well, one of Mr. Kaplan's points was that the court, in a motion to modify decision-making, could not enter orders that didn't have to do with that. But the court did do that here, and they're kind of cherry-picking which ones they're complaining about. Title 14 sets forth 3 situations in which the endangerment standard applies to parental responsibilities orders, and this prohibition simply doesn't fall into any of those categories. It applies to modification of decision-making. This is not a modification. This order prohibiting her from attending appointments is not a modification of decision-making. It applies to a modification of parenting time that substantially changes the parenting time and changes the party with whom the child resides a majority of the time. This clearly doesn't fall into that category. And it applies to restrictions on a party's parenting time. This isn't a restriction on mother's parenting time. In re the Marriage of Parr and Lyman discussed whether a parenting time order that father could not smoke marijuana constituted a restriction. The court found that it did not constitute a restriction because it didn't present a qualitative change in the nature of father's time.
But isn't this different? I mean, The court's order just simply prohibited the mother from even attending the children's medical appointments, which would mean that the mother really doesn't have any way firsthand to get information about the children's medical care. Isn't that a lot different than the marijuana provision?
I don't disagree that it's somewhat different. I don't think it's a lot different, and I don't think it falls under a restriction, which is the third category where an endangerment finding is required. Her parenting time is exactly the same. It hasn't been altered. It doesn't require supervision. She can still participate in the children's normal daily activities, take them to school, take them to therapy, minister to their needs at home. The order here simply deals with whether she can attend medical appointments or not, and she does have ways to get information about the children because she can contact the children's care providers.
Good luck with that. We all know how that goes. I mean, have you ever tried to get your doctor on the phone? Maybe you have a better doctor than I do, but I can't.
Well, maybe I do. I am able to do that, but that's not. But that still doesn't make this a restriction on her parenting time that requires an endangerment finding. The statute for 1410-124-7, under the best interest power, cites some examples of things that fall under that power. One of those things is how often a parent can communicate with a child not on their parenting time. This doesn't strike me as so different from that situation, and it's simply not, it doesn't present a qualitative change on her parenting time, and it's not a restriction.
What's the underlying rationale for the district judge saying you can't attend the medical appointments? I mean, what interest was that trying to protect?
That is trying to protect the children from the harm of witnessing the conflict. The court specifically found that the children were harmed by the pattern of conflict at the doctor's appointments. Father had testified that when they had doctor's appointments, mother disparaged him, she behaved aggressively towards him, she disparaged his family. All of those things occurred in front of the children.
At the doctor's appointments.
I'm sorry?
While at the doctor's appointment.
While at the doctor's appointments.
So why couldn't Judge McGahey just say, I'm going to allow you to attend the doctor appointments, but you better keep your mouth shut. You better not say anything that might be disturbing to the child, because if you do, it's going to be a different ballgame. I mean, wasn't that the reasonable thing to do under those circumstances?
They were already under orders not to disparage each other in front of the children from their separation agreement, and that didn't work. Additionally,
There was also some issues about they're both doctors,
that's correct.
and they seem to disagree in some cases about the appropriate treatment for their children. There was the issue about the antibiotics that were not given. I'll just paraphrase it that way. So was Judge McGahey trying to avoid conflicts with the doctor, him or herself, between the parents in front of the doctor?
I believe that Judge McGahey was attempting to avoid just the parents being in constant conflict. The PRE's report said that where parents cannot get along, which these parents clearly cannot, the only way to minimize conflict is to keep the parties disengaged from each other and to the greatest extent possible not in the same place at the same time.
And that conflict seemed to manifest itself commonly in the doctor's office?
In doctor's offices and about medical issues generally. The court also found several examples of when mother goes to doctor's appointments, she neglects to convey information to father. The court found that she changed medical providers without telling father, she changed dental providers without telling father, she refused to disclose to father the names of the vaccines that the children had received.
But that wouldn't be true under this modification, though. Even if she were allowed to attend, she would be allowed to attend because father would have scheduled it based on the modification, correct?
I'm not sure I understand your question.
On the doctor's appointments, the healthcare issues were moved to father, right?
That's correct.
So it's not like he would be left in the dark at this point going forward based on that modification.
That's correct. I think what I'm addressing is the potential question coming up that, well, couldn't mother attend some on her own and father could attend some on his own, and here's the reason she can't attend them on her own. Okay. Even in the event that the court finds that the standard here should be endangerment, The court, this court finds the standard should be endangerment. The trial court found that. It found that the conflict taking place at the medical appointments was harmful to the children. The trial court had Dr. Budd's testimony and report stating that conflict is harmful in a field where not much else is clear. The single best predictor of poor long-term outcomes for children of divorce is exposure to conflict. The court also,
You're equating harmfulness with endangerment?
yeah.
Okay.
Dr. Budd's report also noted that he found both children to have already shown signs of emotional distress, and minimizing conflict is crucial. Father had testified that the older child's previously close relationships with his family members had already been harmed by the conflict, and one of the issues that came up at medical appointments was that mother started denigrating his family. I'd like to turn now to the First Amendment argument with relation to this issue, and mother,
Before you go there, can you tell us more generally, is the Constitution in play in this case, or are we only dealing with statutory standards?
I believe we're only dealing with statutory standards because In re the Marriage of De Palma and In re the Marriage of Cheslick both state that where you have parent versus parent, they have equal constitutional rights, and the dispute between them has to be resolved in the child's best interests. Mother doesn't have special standing over father when it comes to the modification of decision-making or even who may attend medical appointments. I'll turn now to the First Amendment issue in this matter. Mother relies on In re the Marriage of Newell to say that her First Amendment rights are being trampled by this order. In re the Marriage of Newell was very different. In that case, the court prohibited the father from giving his opinion about his child's care to anyone at all. Here, she can't give her opinion about her child's care during the 15 or 20 minutes or an hour that they're at the appointment, but father has to tell her about the appointments as soon as she makes them. He has to tell her the results as soon as he gets back. She has the opportunity, both before and after, to speak to the children's medical providers. I'd like to move now to whether there was evidence of harm or of endangerment in this case to modify decision-making. There unquestionably was. Mother used her joint decision-making in a way that threatened the children's safety when she changed the medical providers without telling father, stopped the antibiotics without telling father, didn't tell father the names of the vaccines. If he doesn't know what medications the children are or aren't receiving, or where to go to get that information, the children are at very high risk of not receiving proper medical care or receiving contraindicated medical care. Mother also did not let the father know that the younger child had been enrolled in speech therapy, and father didn't find out till the child was four sessions in. If these decisions are made without father knowing what was going on, the child may miss a session, she may miss out on additional therapy work that's required at home, she just may not get the assistance she needs. Second, the court also found that not only did mother make unilateral decisions, but she did not respond to father's requests to engage in decision-making. And as a result of that, father had testified it took them 5 months to pick a therapist for the children simply because mother wouldn't respond and they had to involve their decision-maker. Mother's unilateral decision-making also systematically and repeatedly excluded father from important decisions involving the children. He testified to concern that as a result, the children were harmed because they did not see him as a responsible adult. Dr. Budd, in his report, repeated those concerns. This was a big reason that father believed that decision-making needed to be modified, and the court found his testimony credible. I'd like to talk now a little bit about the impairment of emotional development. One of the points that mother makes.
Before you go there, is there some either express or implicit requirement that an order of this type be the least restrictive required to protect the child?
I believe Your Honor is talking about the least detrimental alternative. Per In re, the Marriage of Martin, the least detrimental alternative is subsumed within the concept of best interests. So while the court didn't make an express finding that modifying decision-making was the least detrimental alternative, it made very thorough analysis of all of the best interest factors and concluded that it was in the children's best interest to modify decision-making. But Mother also doesn't specify what a less detrimental alternative could be when it came to modifying decision-making. The court could modify it or it could not modify it. She didn't propose anything in between at the trial court level.
Well, but isn't it obvious, as I said before, I mean, one alternative which would be less restrictive of the parents' rights is just to say, yes, the mother can attend the medical appointments, but she's got to keep her mouth shut.
Well, they were already under that order, Your Honor, and that order clearly wasn't working to prevent the conflict at the medical appointments. When the existing order that tells the parents not to disparage each other in front of the children is not working out, the court has to enter a new order to protect the children from harm. With respect to the impairment of emotional development, Mother wants to interpret the statute to mean that impairment of emotional development means that children have to be showing present signs of emotional harm. But a situation or a parent can impair a child's emotional development long before the child starts showing symptoms of the damage. If we take, for example, a parent calling a child stupid or worthless, that could go on for months or years, particularly with young children, before they start doing poorly in school or wetting the bed or cutting on themselves. But I don't think anyone would argue that calling your child stupid or worthless impairs the child's emotional development, regardless of whether the child is currently showing symptoms of that damage. To the extent that this court finds a need to interpret 1410-131 with respect to impairment of emotional development, it should interpret the statute consistent with the intent of the legislature to mitigate the potential harm to children from dissolution. The court shouldn't have to wait until the children are showing symptoms of emotional damage before they can modify decision-making. And we have those, even if the present harm is necessary, as I've already discussed, the children were already showing signs of that harm. Father had testified that the older child had displayed signs of distress that needed to be worked out in therapy. Dr. Budd's report found that both girls had already displayed signs of emotional distress. Minimizing the contact between the parties is crucial to minimizing the conflict. Every issue that these parties tried to talk about resulted in conflict. The court found they were completely incapable of making joint decisions for these children. I'd like to turn to the advantage of the change outweighing the harm. This finding that the advantage of the change outweighed the harm was implicit in the trial court's order, and the record supports the court modifying decision-making. And I see that I'm out of time.
Thank you, counsel.
Thank you.
I think you have about 3 minutes and 52 seconds.
Exactly. Thank you.
That's what it says.
The problem that the appellee's argument presents is a practical one. And Judge Berger, I'm sorry, not yet Justice Berger, but you said, well, let's look at reality here. How are you going to communicate with the doctors in a way? I mean, this order, the initial order, provides a father with 14 days, essentially. He has 7 days in which to make a decision whether to take the child who has a 103-degree temperature to the doctor. And then mother has 7 days to respond. If she responds immediately, father then has another 7 days to tell her what his decision is going to be. So we have an order, the initial order, which by itself is so outrageous in the sense that it invades not only reason, but also the mother's constitutional rights, and we'll get into that. But just in terms of endangerment, the order itself goes too far. It doesn't provide an adequate, reasonable remedy for the problem. The problem is if a child is sick, and mother has the children because they have a 50-50 parenting schedule, mother can't take the child to the doctor until the child becomes so sick that it's an emergency. And up until that point, the father gets to sit back and decide if he wants to do it or not. And if he doesn't believe mother because he doesn't like mother, he doesn't trust mother, because if he has a legitimate reason to question mother, that child is going to be harmed because the child isn't going to get to the doctor. So this initial order is extreme and goes beyond the least detrimental alternative. Because that is, the Martin case does say, you try to find the least detrimental alternative. Let the child be taken to the doctor. If the child has strep and mother is parenting this child, let the mother take the child. But there are ways to minimize the conflict. There are less detrimental alternatives in terms of communication protocols, in terms of a much narrower time frame to advise the other parent, hey, your daughter's sick, I need to take her to the doctor, here are some appointment times, can you make one of them? Is it okay if I take her anyhow? Letting you know the school has sent the child home because she's sick, it's my parenting time. All of these things are eliminated by this order. This order makes it harmful to the children rather than deals with any particular harm or endangerment. And that's one of the balancing tests under our endangerment standard, under 1410-131. Is the harm that's created by this order outweighed by the benefit to the child by this order? And the judge never even addressed it, and I'm telling you, or suggesting to you, excuse me, that this order makes the harm worse. If the child has cancer, the mother can't even visit the child.
No, can't go to the doctor's appointment with her.
But as this judge said, you can't go to the doctor's appointment, you can't schedule appointments. I think a reasonable interpretation is you can't even go to the hospital and be there because you're going to be deemed to be creating conflict because father's going to be there or could be there. And a mother, as a physician, has certain obligations to treat people. She has more obligation right now and more rights to treat someone else's child than her own, which is an absurd result of this order. And the school has the right to have the child seen by the nurse at the school. The doctors have the right to provide medical care to these children, more so than the parent, which is why I say there is a constitutional right that's being infringed here. There are two federal cases we cite in our briefs that talk about how medical care is a fundamental right of upbringing or rearing a child. I don't think it's a stretch to say that just like in McSood, that it's like free speech, and just like in Newell, it's free speech, and it involves a constitutional right. Thank you.
Thank you, counsel. Thanks to counsel for their arguments. The case will stand submitted and order will be issued in due course. Seeing that we have no further cases on our docket, the clerk bailiff may announce a recess.